My name is Dan Butler. I'm a professor at WashU, and I'm the Poli-Sci Lego guy. Things were bad for Clarence Earl Gideon, and not just because his name was Clarence Earl. In 1961, he was arrested for breaking and entering. Gideon didn't have any money for a lawyer, and the state of Florida wouldn't help him out. In Florida at the time, free attorneys were only given to those who might face the death penalty. So Gideon represented himself during the trial. That was an epic fail. He was found guilty and sentenced to 5 years in prison. Gideon filed a habeas corpus petition, which is basically a challenge to being detained. Gideon argued that his constitutional rights were violated because he wasn't given a lawyer. The Florida Supreme Court denied his claim, so Gideon asked the Supreme Court of the United States for help. The question that needed answering was, does the Sixth Amendment's right to counsel in criminal cases extend to felony defendants in state courts? In other words, should the state have given Gideon a lawyer? The Supreme Court unanimously agreed that the Constitution requires the state to appoint attorneys for defendants who can't afford them in these cases. Later decisions expanded the right to counsel in some non-felony cases too. By expanding the right to counsel, Gideon v. Wainwright promotes fairness by ensuring that no one is denied legal care just because they lack the money to afford it. However, even with a decision in Gideon v. Wainwright, public defenders today are often overworked and underfunded, leading to concerns about whether poor defendants receive the legal help they need.